Hello viewers, welcome back. My name is Raymond Otieno and I'm delighted to see you all joining the Law Chambers. In this channel, we are here to educate you, inform you, and give you highlights on your legal rights. Remember, your rights is our business. Today on our show, we are going to roll down the carpets on our first episode of the legal aspects of death sentence. Now, let's get to the game. Welcome, Wakili.
Thank you very much.
For those who doesn't know you, please, may you just introduce yourself again and also tell them what you do and also your area of specification so that you can be able to get into the main topic.
Thank you very much. Hello, viewers. My name is Joshua Maritim. I'm a practicing advocate in the town of Eldoret. I deal with courtroom matters. I'm a litigation lawyer. Yes, I was admitted in the year 2011 and started practicing law. I've worked in various organizations, including corporate institutions and also in private practice. I believe the couple of years that I've been in practice has enriched my interaction with the law on some of the aspects we're going to discuss today. As we spoke last time, we talked about criminal culpability for offenses that attract the sanction of death. That is, we have murder, which we all know is the killing of someone with intent. I'll expound more on the intent part. We have treason, which is also punishable by death, and we have robbery with violence. Let me start with robbery with violence. Robbery with violence connotes that either one is where someone uses a weapon when committing the act of robbery. Two, where he is in the company of more than one person when they are committing the robbery act. Or thirdly, where out of the robbery act itself, violence is meted on someone. Those ones would connote robbery with violence. And this is what we mean is that either you use a threat of a weapon or an actual weapon in carrying out the offense itself. So, upon conviction, when one is convicted, you're taken through the criminal process. Upon conviction, the sentence that will be handed down will be one of death. We've spoken about treason. These are offenses that touch on the presidency. If you do anything to maim a president or to try and overthrow a government, those ones are called treason or treasonable offenses. These are offenses that come from way back. They were offenses that were there in the penal code way before we attained our independence. They've been there until with the 2010 constitution. Those offenses are still being there. And third one is also murder. Murder, if you commit murder, you'll be sentenced to death.
On that point, Wakili, I understand that when someone is convicted or sentenced to death, this is somebody that should be hanged.
Yes.
But when I was getting back to the books, I found that it's now 35 years down the line, people are being convicted to death sentence, but they're not hanged, they're not being killed. Now, I was asking, is death sentence still active or is just a word from the judgment part of it?
It's interesting to say that because a while back, someone by the name Francis Muwatetu filed a case before the Supreme Court challenging the constitutionality of the offense of on the sentence of for death sentence. That under our constitution, it is found because murder as an offense is stipulated in the penal code. It's under section 203 of the penal code, and the penal code is a statute book that is below the constitution. And they were challenging the constitutionality, which actually means they were looking at that provision within the constitution vis-a-vis what is in the penal code.
Yeah.
And he successfully prosecuted his case before the Supreme Court,
Yeah.
and the Supreme Court found in favor of the petition and declared that the absoluteness of the offense of the sentence handed down in a murder conviction, he found it to be unconstitutional, and most of those cases were sent back to the trial courts for resentencing, so that new sentences could be given. Let me try and explain and elaborate this further. What in actual sense it says, it is that telling a judicial officer or telling a judge, because trials for murder are done in the High Court, telling a judge to only convict to only sentence a life in prison for death sentence, denied the judge the discretion to consider it vis-a-vis the facts that are there. But let me break down a few things.
Yeah.
I know I've spoken about so many things which we might have glanced over. When somebody is found to be at fault, he'll be taken before a judge for plea taking. But before plea is taken, especially for murder cases and these capital offenses, and with capital offenses, we're talking of murder, treason, and robbery with violence. The first thing usually you will hear is that they want to confirm his mental capacity. Can he go through a trial? Is he mentally stable, competent to stand a trial? And will be taken for mental assessment. Upon assessment, if he's found to be that doesn't have any mental issue, he will now go will take plea. Then plea, the charges will be read to him as provided for. There are two parts to a charge of murder. What is the provision on the law, and the second aspect of the charge sheet will be the facts that they need. So he will plead to both of them. Pleading is saying whether it's true or not. So if you plead guilty for murder, the conviction will be the plea will be recorded and will be found to have been convicted. Conviction is that pronouncement that you've been found guilty of that offense. Yes. So if not, you'll go through a trial where the prosecution, and this is usually the Office of the Directorate of Public Prosecution, having a prosecutor, will call his or her witnesses, who will come and lay down the facts as they are, including the expert witnesses. Those ones include a medical doctor who confirmed the death and produce documents to support that. If there was an arresting officer, he will also come to bring that. If somebody was handed over by members of the public, you will have something called a rearrest. You are brought to the police station, then there's an officer who will rearrest you after being presented. And then we have also an investigating officer. All these people will come and testify and give their testimonies to that effect. And then the prosecution will close their case. In between, while the testimonies are going on, as you're all aware, there will be a process called the examination in chief, where evidence is being tendered. There will be cross-examination where the accused person will be given an opportunity, in most cases through their appointed lawyer. And let me say almost in all cases, because for these offenses, because they are attract a death penalty, it means that what would happen is that you get your own lawyer to represent you. If you can't, the state or government will appoint for you a lawyer.
That brings me to get to another question.
Yes.
I committed a murder.
Mm-hmm.
Let's say, for example, I committed a murder, and I'm now being brought to charges.
Yes.
Who is the complainant here? Because the person that you'll be complaining is dead.
Yes.
So the complainant is the family members, or who is the complainant here?
We have two things we have to look at. In this case, the complainant is the state, and that is government.
Yeah.
And that is, they are represented through the police, who will carry the investigations and present charges to court on behalf of the victim. In this case, the victim is a deceased person, and you have the family members who are live victims. Because of the offense that was committed, they have suffered, and now we have new developments in the law. We have an act called the Victim Protection Act, which caters for the interest of those people who've presented complaints or presented cases before the police for them for justice to be given to them. So that is one. I was still explaining to you that upon the close of the prosecution case, the judge in this case, because murder cases are heard before the High Court, they will have an opportunity to analyze the evidence and call for submissions or arguments to see whether there is a case to answer. And after that, the court will decide whether there is enough evidence, what we call a prima facie case. Is there enough evidence to take this person to the next stage where he's supposed to give his testimony to explain to explain himself, he or herself out
to take
the defense part. So if on a case to answer, they find that there is no prima facie case, that is the end of that case. If the accused person is found to have a prima facie case, then it proceeds to the second part of the case, which is the defense case. The defense will also tender their testimonies, and before we go to the defense, they are usually the accused person is told to explain himself, to elect which mode of defense he will take. Will he take sworn testimony? Sworn testimony means he assumes the same rights and privileges as a prosecution case, where he moves. If you see in a court setup, there is usually a dock where the accused persons are, and there is a dock for witnesses. So he will move from the part of an accused person and move to the other dock.
So
he becomes the first witness. He'll be sworn, and he gives sworn testimony. Sworn testimony is testimony where you lift the holy books, whether it's a Bible, Quran, or the Gita. You can also affirm. Affirming means you raise your, in this case I'm raising my left hand, but you can raise your right hand and affirm without calling upon the name of God or any superior being, but you affirm that whatever you say is the truth. Without you can neither swear or affirm. Swearing is you use a Bible or a Quran or a Gita or any of the holy books. But when you're talking of affirmation, you just raise your hand. And I know most people, there are certain people who are not comfortable swearing for one reason or the other. They are allowed to affirm. Then after the testimonies have been given, after the end of the close of the defense case, the judge will then go back and write down a judgment, analyzing the evidence as was presented, and will deliver whether it's a conviction where somebody has been found to be guilty, or an acquittal when he is found not to have been guilty. The essence of a trial in our system, which is an adversarial system, is not necessarily to say that you did the offense or you did not do. What our system does is that it will analyze from the evidence as presented to court. Is it enough to secure a conviction or not? So you usually you'll be convicted or acquitted depending on the evidence that was tendered
on the table.
Yes, if the evidence is enough to secure conviction, you'll be convicted. If not, you'll be acquitted. And this point we are saying you've been found to be guilty. Then there are usually other processes that would take place. After a conviction, we would have something called mitigation. Explain mitigating circumstances that the court will consider while handing down the sentence. Though in murder cases, there's only one sentence, sentencing, which is actually the final penalty you will face is usually one for death.
Now, this procedure, they do apply to both murder, robbery, and any other criminal offense, capital offense, or they are this just for murder procedures?
The process I've explained largely is for murder, but also with slight modifications for robbery with violence.
And here comes someone who killed. Yes, I killed. I've murdered the deceased, but now it was not intentional.
Yes, it's good that you brought out that
I
issue.
Killed, yes, and I know that yes, I killed him, but now this was not intentional, or I was forced to do this. How do the law?
Yes, Justice Abruli, not long ago, handed down a sentence of 1 day. Justice Abruli, judge of the lady judge of the High Court, for an offender who had killed her husband. And the circumstances were such that she did not kill with intent. And it takes me to the next point I wanted to bring out. For a conviction of murder, and in most cases, criminal cases, criminal cases have two aspects in it. There is the guilty intent, the thinking behind it before you execute a criminal offense. Yes. And then there is a second aspect, which is the act itself. In Latin is it's called actus reus, which is the actual act, and we have mens rea, which is the malice aforethought, or the thinking that came,
planning,
yes,
and heading to the action.
Yes. For an offense where somebody did not pre-plan or did not premeditate before committing the offense, that is commuted from murder to manslaughter. And manslaughter is where you kill without intent. You do not intend to do that. There are myriad of examples that are out there. You hear of someone goes into the house, and then he finds that his wife, God forbid, is with somebody in bed, and out of anger they get into a fight, and stabs the person or hits him with an enemy, or pushes him, maybe falls into a ditch or falls down, hits his head, and then unfortunately the person dies. That one, from the circumstances, you'll tell that he did not come with the intent of killing this person. Or there are instances, and there's also a myriad of defenses that are usually given when somebody dies, because life is sacred. At the end of the day, irrespective of the circumstances, every life is sacred, and life needs to be preserved. And even if it is justifiable, the court will not just let you scot-free, because there is an essence in which the law intends also to cause deterrence for these offenses. But because of time, so that we don't take a lot of time on this, upon conviction, then mitigation, we will also have a victim impact statement. The victim can also tell court what their perception is of this person before the court hands out the sentence. And then we have, in other cases, the court would also ask for a probation report, depending on the circumstances, before a sentence is handed down. And then after that, the sentence will be given. But as I've told you, for murder, there's only one sentence that will be given. It's death. They hand down the offense. There is nothing like. But with the decision in Murwatetu, courts have been given latitude to give sentence and to give sentences that are equated to what we call life in death sentence.
Yeah.
And in this case, we look at sentences they usually give about 25 to 30 years imprisonment, which is equated. There's a long debate on how that sentence is handed down, and there's still debate on that issue.
Yeah.
The law has not crystallized. We don't have a uniformity, but at least with the decision from the Supreme Court on Murwatetu, murder convicts are being resentenced who had been convicted initially. They are taken for resentencing, and they'll be handed over sentences for the number of years that the judge would have the discretion.
Yeah.
Let me come to robbery with violence. Robbery with violence are offences that are had before in the magistrates court, which means unlike the one in the High Court, this one are had in the magistrates court. For robbery with violence, this is we have normal robbery, which is somebody you use force, violence,
Yeah.
steal from someone. But there are these mitigating circumstances where you use an offensive weapon, or it's more than one person who are in this the transaction of committing the robbery. That becomes robbery with violence, where you use violence or threat. You use actual violence in the company of another person, or even if you're alone with an offensive weapon, or you threaten either before or during the commission of the offense, or even after, telling that if you ukiongea, we will deal with you. Those
So meaning
circumstances.
it's not a must I beat you.
Yes.
Hata kukutishia tu, just threatening and tell you if you dare,
Yes,
I'm killing you today.
Yes.
So that's a robbery with violence.
That becomes robbery with violence.
Even
So long
just
as
a slap.
if you've stolen from that person.
So meaning, I've come to steal your pen.
Yes.
And I slap.
Slap me
And I
senseless, and I lose conscience or something like that. That becomes
or I threaten you and
I
tell you, my friend,
tell you,
if you dare,
dare,
just try to call the police. You
yeah,
see,
yeah.
I have a knife here.
Yes.
That's a robbery with
That
violence.
becomes robbery with violence.
Yes.
Yeah. And also where you are in the company of you and somebody else.
So meaning, even if I don't threat you, but we are like three, that's
yes,
a robbery with
that
violence.
becomes robbery with violence. And the offense of stealing, that's you steal from that person, that becomes robbery with violence.
So let me understand something here. How does it come a robbery with violence if we are just three and we don't do anything? We just steal and we go.
But there's the act of violence that you use, but because there is a normal stealing where you would steal from somebody, run away.
Yeah.
But there is the actual sense, because it's robbery violence. There's a menace that comes with it.
Yeah.
There is that use of force. Maybe you
because
are.
Once you see three guys,
yes, and
strong,
and they come steal from you, and there's that element. There should be an element of violence or an element of threat that you feel that your life is in danger.
What's the minimum sentence of general robbery or normal robbery?
Normal robbery is 14 years.
40 years.
14 years.
14 years.
Yes.
So a normal robbery is
which is still a serious offense as it were.
Yeah.
Where I'm coming to steal from you without an offensive weapon, but I come steal your phone, and I get away with it.
You grab it by force.
Yes.
So there's a difference between
that you can tell that you've been robbed. Yes, breaking and stealing entails that there's a building or a house where you break into. And there might be someone inside or not.
That's also a criminal offense.
It's a criminal,
but
also
not fall under death sentence.
It doesn't fall under the death sentence.
Now, the last question, or something that I would wish you to help my viewers to understand: robbery with violence, murder, and treason.
Treason, yes.
Now, we have terrorists.
Yes.
someone who kills, does all sort of things.
Mm.
Is this a capital offense, and what are the charges?
Yeah, they are capital offense, and in fact, we have a standalone act on terrorism.
Yes.
And from the statute books, the offense handed down for terrorists or such related is a life imprisonment.
Life
Imprisonment. I know there is this question that so far we've never had anybody hanged.
That was my previous question. Yeah.
Yes.
Nobody has ever been hanged. Me, I'm born 93. Since
Yes.
93 till to date,
Yeah.
it's 30 years down the line. But when I was reading back to the books, nobody has ever been hanged. And here I can see our judges are just sentencing people to death sentence. Death sentence.
Yes, it's true. As it is, most of them, once somebody is convicted and sentenced,
Yeah.
we have once you're handed to the prison, the president has the power of pardon and clemency through the power of clemency. There is a body
Yeah.
that deals with pardoning offenders, and in most cases you'll find that all death sentences are usually commuted to life imprisonment.
Okay.
What in actual sense it means is that somebody who's been sentenced to death and ends up serving time for their yes, it's been there. But now with the Muriwatetu case, you're given actually a definite number. It's not an indefinite sentence. You'll be told that for this you'll be serving for 30 years, or maybe for 40 years, or maybe for 20 years, depending on, because that one comes to the discretion of the judge to hand down the sentence. You said you have the conviction, and after conviction, you'll be handed down a sentence which says the punishment you'll be meted.
On our previous judgments in Kenya,
Mm.
there is a previous judgment that hit all over the media about the sentence, and I overheard the accused or the convict was saying that I'm going to do appeal.
Yes.
Now I'm sentenced to death. We count as a dead person, and here I'm saying that I'm going to appeal for the matter. Can you help my viewer to understand the procedure of appeal of a death sentence?
Thank you very much. That is quite an insightful question. In that, if your case is being heard in the magistrate's courts, in this case, a robbery violence, if you are sentenced to a death sentence, I think it's only prudent. To try your luck in the next higher court, and in this case, you appeal to the High Court.
Yeah.
And if you are not satisfied, you can still appeal to the Court of Appeal.
Yeah.
If it's a murder case, you can still appeal to the Court of Appeal. And also, you remember I've talked about this case of Francis Muriwatetu.
Yeah.
You can still petition to the Supreme Court on the interpretation on that, because the Supreme Court does not deal with cases that deal one-on-one with you. The highest you can go is the Court of Appeal, but you can go on interpretation of the Constitution and all those provisions that are given under the Supreme Court Act and the Constitution, including interpretation and hearing cases of general public importance. If you frame your case within that scope, you'll be able to be heard at the Supreme Court. And we've seen that the Muriwatetu is just but one. There are so many other cases that have been heard on issues that are touched on various aspects of the law. And one of the beauty we have with the Kenyan Supreme Court is that it is the final court, and if there are conflicting decisions handed down by different courts, and like in our Kenyan system, we have the doctrine of precedence, where a decision of the High Court will be binding to the courts below the High Court. If there's a decision of the Court of Appeal, it's binding to the High Court and the courts below it. And if there's a decision of the Supreme Court, it will be binding the Court of Appeal, the High Court, and the courts below them. Yeah. So if there are different decisions, let's say for instance,
Yeah.
the decision that has been heard at the High Court and there are conflicting findings of the High Court, you can progress it to test it before the Court of Appeal. If there are conflicting decisions in the Court of Appeal or there is no pronouncement, by pronouncement we mean there is no decision that has been delivered at that level, you can escalate it now to the Supreme Court. And once the Supreme Court delivers a decision on that, it settles that matter, because our judicial system is one we borrow from the Commonwealth. It's a common law jurisdiction. Common law, what it actually means is that cases are tried and the decisions refined along the way until you get the best decision. Not the best, but the most sound reasoning behind that law. And at the apex, which is in a Kenyan jurisdiction, is the Supreme Court. That one will be handed over and it will be used across the board. Though there are instances that the Supreme Court can depart from its own decision. It's the only court that can depart from its own decision. If it can give a decision today, but if there are more reasons to move from that kind of reasoning to another, the Supreme Court can vary and change. And
so they can change their judgment.
They can not the judgment per se, but the reasoning behind that, because every case has its own set of facts and a decision handed down. But the reasoning behind that decision, they can give another decision based on the same set of facts, but same set of circumstances, different facts. But they can depart from the initial, and that this has been seen in our election cases where the decisions were handed over at one point, but there's been a sense in which it's not normal. It's on rare cases that the court will depart from its reasoning.
Okay. Yes. Thank you so much, Kini. Maybe if there's any other thing that you can add or insight on it, so that to be a benefit to our viewers there, and also to someone that is watching this show over the death sentence matter, just a close-up remarks.
Thank you. For the viewers, first, I'll call upon you to uphold the law at all times. When you uphold the law, you're not doing anyone a favor. It's what is expected of anyone in any civilized society. And secondly, if whenever you feel that your rights are infringed, you have the right to seek legal redress in our courts of law. And now we have various avenues to seek redress in the various forums. And the discussion we've had today, is a huge topic. In law school, they are taught for a semester or two on some of these topics. But we're just giving a highlight. If for every case that you have and you wish to have it articulated, what you do, seek legal advice from a lawyer or a legal practitioner who is competent to do that. This is meant for general education purposes. And thank you for your time. Thank you for tuning in. And until next time.